हॅलो गाईज, वेलकम टू इझी लिगल लॉ. आपण पाहत आहोत रिअल इस्टेट लॉज. तर कंटिन्यू करूया रेरा इस्टेट लॉज. अंडर द रिअल इस्टेट रेग्युलेशन अँड डेव्हलपमेंट ऍक्ट 2016, the traditional buyer-seller dynamic has been replaced by a regulated tri-party relationship between the promoter, allotee, and the real estate agent. The Act defined these relationships not just through a contract but through statutory obligation that ensure transparency and accountability. Promoter and allotee, the core relationship. This is the primary relationship in real estate. Rera shifts the principle from caveat emptor to caveat venditor. तर एक जी बेसिक एक मॅक्सिम आहे कॅव्हिएट एम्प्टर, म्हणजे त्याचा अर्थ होतो बायर बी अवेअर. तर जेव्हा कधी बायर एखादी गोष्ट घेतो तर त्याच्यावरती त्याला सल्ला असतो की त्याने जागरूक असलं पाहिजे. जर त्याच्यावर कोणता अन्याय झाला असेल तर त्याने अथॉरिटीला अप्रोच केलं पाहिजे. पण रेरामध्ये कॅव्हिएट वेंडिटर म्हणजे सेलर बिवेअर, म्हणजे सेलरने जास्त काळजी घेतली पाहिजे विकताना, त्याने रूल्स फॉलो केले पाहिजे. बायरसाठी कमी रूल्स अँड रेग्युलेशन आहेत, सेलरवरती जास्त आहेत. ट्रस्ट अँड फायनान्शियल अकाउंटेबिलिटी. द रिलेशनशिप इज बिल्ट ऑन द 70% escrow rule. The promoter must deposit 70% of the funds received from allottees into a separate bank account to be used solely for that specific project. This ensures the allottees money isn't diverted. तर मी तुम्हाला मागच्या लेक्चरमध्ये सांगितलं होतं की 3 अकाउंट्स ओपन करावे लागतात प्रमोटरला, ज्याने जो की मेन असतो कलेक्शन अकाउंट. या अकाउंटमध्ये जेव्हा पैसे येतात बायरकडनं तर ते सेग्रिगेट होतात सेपरेट 2 अकाउंटमध्ये. एका अकाउंटमध्ये 70% आणि एका अकाउंटमध्ये 30% जातात. मग ते 70% ते होल अँड सोल त्या प्रोजेक्टच्या कम्प्लिशनसाठी यूज केले जातात आणि यावरती रेराची नजर असते. Adherence to sanction plans. The promoter cannot make any minor addition or alteration to the sanction plan without consent of the allotee. A major alteration without the written consent of 2/3 of the allottees. जेव्हा कधी प्रमोटरला बिल्डरला आपल्या प्लॅन मध्ये काही चेंज करायचा असेल तर त्याला त्यावेळेस अलॉटीची परमिशन कन्सेंट घ्यावी लागते. जर मायनर चेंज असेल तर 51% कन्सेंट पुरेशी असते. पण जर मेजर अल्टरेशन FSI चेंज करायचा आहे, काही नवीन FSI TDS ऍड करायचं आहे, तर अशा वेळेस 2/3 अलॉटीजची कन्सेंट घेण्यात येते. डिफेक्ट लायबिलिटी. A unique warranty relationship exists where the promoter is responsible for structural defect for 5 years after handing over possession. पोझिशन दिल्यानंतर सुद्धा 5 वर्षासाठी बिल्डरची लायबिलिटी असते त्या स्ट्रक्चर बद्दल. Reciprocity of interest. If promoter delays possession, they must pay interest to the allotee. Conversely, if the allotee delays payment, they must pay interest to the promoter. Rera mandates that rate of interest must be same for both parties. जर प्रमोटरने डिले केला पोझिशन देण्यासाठी तर त्याला जी अमाऊंट आतापर्यंत बायरने जमा केली आहे त्यावरती इंटरेस्ट द्यावं लागतं. ऑर एल्स किंवा अलॉटी बायरने जर पेमेंट इन्स्टॉलमेंट भरण्यास उशीर केला तर त्याच इंटरेस्ट रेटवरती त्याला पण प्रमोटरला फाईन पे करावा लागतो. प्रमोटर अँड रिअल इस्टेट एजंट. द एजन्सी रिलेशनशिप. द एजंट ऍक्ट्स ॲज द extended arm of the promoter but with a regulated boundary. Authorized marketing. A promoter can only use RERA register agents to sell their project. तर जे कोणी प्रमोटर आहेत ते फक्त रेरा रजिस्टर एजंट्सच यूज करू शकतात आणि जे कोणी रजिस्टर एजंट्स आहेत, जे त्यांचे रेरा एजंट्स आहेत, इस्टेट एजंट्स, हे पण त्यांना त्यांच्या वेबसाईटवरती मेन्शन करावं लागतं की कोण आहेत आमचे रिअल इस्टेट एजंट्स. Shared responsibility for truth. If an agent make a false promise or provide a misleading brochure provided by the promoter can be held liable for compensation to the buyer. Project documentation. The promoter is responsible for providing the agent with all update authenticated documents, sanction plan, RERA number, so the agent can accurately inform potential buyers. Real estate agent and allotee. The advisory relationship. This relationship is defined by the fair trade practices. The agent is no longer just a salesman, they are a professional advisor. Right to information. The agent has a duty to provide the LOT with all documents and information they are entitled to at the time of booking. Prohibition of misleading conduct. The agent is liable if they engage in unfair trade practices or misrepresent the project amenities or completion status. Facilitation. The agent's role ends only when the transaction is completed and the LOT has been properly guided through the administrative process. Next consider the agreement for sale, a legal anchor. तर बेसिकली अग्रीमेंट फॉर सेल काय आहे, जेव्हा कधी आपण एक फ्लॅट घ्यायचा ठरवतो तर ते ट्रान्झॅक्शन करायचं याच्याच बद्दल आपण अग्रीमेंट करतो की आपल्याला तो फ्लॅट विकत घ्यायचा आहे, त्यासाठी आपण अग्रीमेंट फॉर सेल करतो. त्यामध्ये आपण जी प्रॉपर्टी आहे त्याचं डिस्क्रिप्शन, परत त्याची व्हॅल्युएशन, कोणत्या पद्धतीने आपण पैसे देणार आणि किती टप्प्यांमध्ये देणार, त्यामध्ये पोझिशनची डेट काय असणार आहे, हे सर्व गोष्टी आपण मेन्शन करत असतो. The relationship between all parties is formally cemented by the model agreement for sale prescribed by the state RERA rules. Unlike the old days when builder had one-sided contracts, RERA mandates a standardized agreement that protects the buyer's right. A promoter cannot accept more than 10% of the cost of the property as an advance booking fee without first entering into a written agreement for sale and registering it. तर पूर्वी बिल्डर्स त्यांच्या पद्धतीने कॉन्ट्रॅक्ट बनवायचे, वन साइडेड कॉन्ट्रॅक्ट असायचं, त्यामध्ये बायर्सला काहीच करता येत नव्हतं किंवा त्यांचे जे राईट्स आहेत ते हॅम्पर व्हायचे. पण आता रेराने स्वतः एक स्टँडर्डाइज अग्रीमेंट स्वतः प्रोड्यूस केलंय, स्वतः बनवलंय आणि गाईडलाईन्स दिली आहे की या अग्रीमेंटानुसार, या गाईडलाईन्स अनुसार हे अग्रीमेंट बनवलं जाईल. आणि त्यामध्ये अजून एक कंडिशन आहे की 10% पेक्षा जास्त कॉस्ट बुकिंग अमाऊंट मध्ये बिल्डर घेऊ शकत नाही विदाउट अग्रीमेंट फॉर सेल. अग्रीमेंट फॉर सेल हा रेराचा खूप इम्पॉर्टंट पार्ट आहे. या बेसिसवरतीच खूप सारे लिटिगेशन्स किंवा खूप साऱ्या जे पोझिशन्स आहेत त्याची डिमांड करता येते. प्री लॉन्च फेज, ॲडव्हर्टाइजमेंट अँड मार्केटिंग. बिफोर अ सिंगल ब्रिक इज लेड or an ad is published, the promoter has strict gatekeeping duties. Mandatory registration. No promoter can advertise, market, book or sell any unit without first registering the project with the state RERA authority. Truth in advertising. Any advertisement or prospect must be completely honest. If a buyer is misled by false pictures or promises, example, a proposed swimming pool that never arrives, the promoter is liable to return the buyer's entire investment with interest. Website disclosure. Once registered, the promoter must maintain a web page on the RERA website. This page must display the RERA registration number, sanction plans, and a list of approvals received or pending. Booking phase, allotment and financial discipline. This stage focuses on protecting the buyer's capital and ensuring the project is financially viable. Limit on advance payment. A promoter cannot accept more than 10% of the property cost as the booking amount without entering into a written and registered agreement for sale. The 70% escrow rule. The promoter must deposit 70% of all money collected from buyer into a separate bank account. Withdrawal logic. Money can only be withdrawn in proportion to the percentage of completion of the project. Certifications. Every withdrawal require a certificate from an engineer, an architect and chartered account. Document delivery. At the time of booking, the promoter must provide the buyer with sanction plans, layout plans and stage-wise schedule for completion including water, electricity and sanitation. सो यामध्ये तेच सांगितलं आहे की 70% त्याला ते सेपरेट अकाउंट मध्ये मेंटेन करता येतात आणि ज्या पद्धतीने प्रोजेक्ट कम्प्लीट होईल त्या अकॉर्डिंगली त्याला ते पैसे विड्रॉ करता येतात फक्त प्रोजेक्टच्या कामासाठी. आणि हे सगळ्या गोष्टी तो पैसे त्या प्रोजेक्टसाठीच वापरले गेलेत हे कोण सांगता आपल्याला. ह्या सगळ्या गोष्टींना क्रॉस चेक करण्यासाठी इंजिनियर असतात, आर्किटेक्ट असतात आणि सीए चार्टर्ड अकाउंटंट असतात. Construction phase, adherence and transparency. During construction, the promoter is a custodian of the project specification. Adherence to plan, promoter must build exactly what was sanctioned. Minor changes require the consent of specific allottee. Major changes, example, adding a floor or changing the layout, require written consent from 2/3 of all allottees in the project. तर मायनर चेंज असेल तर स्पेसिफिक अलॉटीची परमिशन घ्यावी लागते. जर फ्लोर ऍड करायचा आहे, कोणता युनिट ऍड करायचा आहे, तर यामध्ये 2/3 अलॉटी जेवढे पण फ्लॅट्स विकत घेतलेले त्यातले 2/3 मेंबर्स यांची परमिशन घ्यावी लागते. क्वार्टरली अपडेट्स. The promoter must update the RERA website every quarter with the progress of construction, the number of units booked, and the status of approvals. Title integrity. The promoter is liable to compensate buyer for any loss caused by a defective title to the land even after the project is completed. Completion and handover phase. The promoter's job doesn't end when the building is finished, it ends when the legal title is transferred. Certificates. The promoter must obtain completion certificate and occupancy certificate from local authorities and provide copies to all buyers. Formation of association. The promoter must take step to form association of LOT within 3 months of majority of units being booked. तर जेव्हा मॅक्सिमम फ्लॅट बुक झालेत त्यानंतर 3 महिन्यामध्ये बिल्डरला फॉर्मेशन ऑफ असोसिएशन साठी स्टेप्स घ्यावे लागतात. कंप्लिशन सर्टिफिकेट आलं, ऑक्युपन्सी सर्टिफिकेट आलं, त्यानंतर लोक पोझिशन घेणार. त्यानंतर जेव्हा एक मॅक्सिमम नंबरचे जे आपले हे आहेत बायर्स आहेत ते पोझिशन घेतल्यानंतर एक सोसायटी फॉर्मेशन होणार. Execution of conveyance deed. The promoter must execute a registered conveyance deed in favor of all the allotee and association within the specified time frame. एकदा सगळ्यांना पोझिशन मिळाल्यानंतर त्यानंतर बिल्डरला कन्व्हेन्स डीड म्हणजे थोडक्यात जर एक प्लॉट आहे, सपोज प्लॉट आहे, त्यावर एक बिल्डिंग आहे, ज्या बिल्डिंगवर 10 फ्लोर आहेत, तर 10 फ्लोर जर कन्व्हेन्स डीड झालेलं नसेल तर बिल्डरला उद्या जाऊन जर वाटलं परमिशन घेऊन इथं अजून 5 फ्लोर करायचे तर 15 फ्लोरची तो बिल्डिंग करू शकतोय, कारण ती लँड त्याच्या नावावरती आहे आणि बाकीच्या अलॉटीज फक्त त्यांच्या फ्लॅट पुरते मर्यादित आहेत. पण एकदा कन्व्हेन्स डीड झाल्यानंतर ही पूर्ण लँड आणि ती प्रॉपर्टी त्या अलॉटीज मध्ये त्यांच्या शेअर अनुसार त्यांच्या नावावरती होते. त्यानंतर एक्सटर्नली कोणताही बिल्डर किंवा कोणी त्या जागेला डेव्हलप करू शकत नाही अनलेस अँड अंटिल पूर्ण या लोकांच्या कन्सेंट शिवाय. मेंटेनन्स. द प्रमोटर इज रिस्पॉन्सिबल फॉर प्रोव्हाइडिंग अँड मेंटेनिंग एसेन्शियल सर्व्हिस, वॉटर सिक्युरिटी एक्सेट्रा ॲट द रिझनेबल चार्जेस अंटिल द असोसिएशन टेक्स ओव्हर. Liabilities and post handover obligation. RERA introduces long-term accountability through specific penalty and defect clauses. Structural defect liability. Section 14. If any structural defect or defect in workmanship is discovered within the 5 years of handover, the promoter must fix it for free within 30 days. Delay interest. Section 18. If promoter fails to give possession by date mentioning in the agreement, option A, the buyer can withdraw and get a full refund plus interest. Option B, the buyer can stay. The promoter must pay monthly interest for every month of delay. Penalties: non-registration, fine up to 10% of project cost. False information, fine up to 5% of project cost. Persistent default can lead to imprisonment for up to 3 years. Under the Real Estate Act 2016, the publication on website refers to the mandatory digital disclosure of project and promoter information on the official portal of the state regulatory authority. This serves as a digital identity for the project. What is published? Scope of publication. Once a project is registered, the authority creates a dedicated page for it. The promoter is legally obligated to upload and update the following: registration details, प्रोजेक्ट प्रोफाईल, अप्रुव्हल स्टेटस, टाइमलाईन, क्वार्टरली अपडेट्स. क्वार्टरली अपडेट्स मध्ये काय येईल? लिस्ट ऑफ नंबर्स ऑफ टाइप्स ऑफ अपार्टमेंट, लिस्ट ऑफ गॅरेज बुक, द करंट स्टेटस ऑफ कन्स्ट्रक्शन, स्टेटस ऑफ अप्रुव्हल फॉर इच फेज. प्रमोटर इन्फॉर्मेशन, नेम अँड फोटोग्राफ ऑफ प्रमोटर, डायरेक्टर अँड देअर ट्रॅक रेकॉर्ड. एजंट डिटेल्स, नेम अँड ऍड्रेस ऑफ रजिस्टर रियल इस्टेट एजंट ऑथराइज्ड टू सेल युनिट्स इन दॅट प्रोजेक्ट. द इफेक्ट ऑफ पब्लिकेशन. The publication is not just for information. It has significant legal and commercial consequences. Legal: point of no return. Statutory binding: once information is published on the website, it becomes statutory representation. The promoter cannot later claim that a certain amenity or timeline was just a marketing gimmick. Evidence in dispute: in case of litigation or complaints, the data on the RERA website serve as the primary evidence. If the construction status uploaded by the builder does not match the ground reality, it constitutes a false representation. Consumer empowerment: due diligence. It allows a buyer to verify the builder's claim. Example, carpet area versus super built up area, without relying solely on a brochure. Monitoring progress: buyers can track construction progress via quarterly updates from their homes, reducing the need for physical site visits. Anti-fraud mechanism: verification of legitimacy. It prevents ghost projects. A project without a published profile on government portal is illegal to market. Transparency of approvals: it eliminates risk of buying into a project that does not have commencement certificate or environmental clearance, as the documents must be visible online. Regulatory oversight: automated tracking. The authority uses the published data to track project delays. If a promoter misses a completion milestone mentioned on the website, the system can flag it for penal action. Public accountability: any citizen, not just a buyer, can view the database, creating a system of public scrutiny. In RERA framework, the agreement for sale is the contractual blueprint, while transfer of title is the final legal handover. RERA has turned this into strict time-bound mandates to ensure you don't just own a flat on paper, but actually own the land and structure legally. Section 13 deals with agreement for sale. Agreement for sale is the first formal legal document between the promoter and the LOT. RERA has standardized this to prevent one-sided contract. Key rules: the 10% cap. A promoter cannot accept more than 10% of property cost as an advance of booking fee without first executing and registering a written statement for sale. Standardized format: states prescribe a model agreement, while parties can add specific clauses. They cannot override the basic protection provided by RERA. Mandatory registration: the agreement must be registered under the Registration Act 1908, making it public legal record. What the agreement must include: specification, exact carpet area, internal and external development works, payment timeline, a schedule linked to construct milestone, example 10% on completion of plinth, possession date, ज्या डेटला आपल्याला possession मिळणार आहे, the specific date by which public must hand over the unit, the equitable interest clause: if the builder delays, they pay interest; if the buyer delays, they pay interest. Crucially, the rate of interest must be same for both. Transfer of title. Section 17. Transfer of title is the process of legally moving ownership from the promoter to the LOT and the association of LOTs for the land and common areas. The two-step transfer: to the LOT, the promoter must execute a registered conveyance deed for a specific apartment in favor of the buyer. To the association, the promoter must transfer the undivided proportionate title in common areas to the association of LOTs, the society or RWA. Timelines for transfer: RERA sets strict deadlines for execution of conveyance deed. Local law followed: if state laws like MOFA in Maharashtra specifically a timeline, those apply. In absence of local law, the promoter must carry out conveyance within 3 months from the date of issue of occupancy certificate. Handover of documents post transfer: once the title is transferred and possession is given, promoter's legal umbilical cord to the project must be cut. Within 30 days of obtaining the completion certificate, the promoter must hand over sanction plans and layout plans, maintenance records and bank balance, utility connections, any other document necessary for the society to the managed building independently. Under the Real Estate Act, specifically Section 19, the LOT buyer is recognized as a key stakeholder with specific legal entity and responsibility. The Act aims to balance the power dynamic between the developer and the consumer. Rights of LOTs: RERA provides LOT with powerful rights to ensure transparency and accountability. Right to information, the right to obtain sanction plans, layout plans, and specifications approved by the competent authority, along with any other information provided in the act or agreement for sale. Right to know completion schedule, section 19 subclause 2, the right to know the stage-wise schedule for project completion, including essential service like water, electricity, and sanitation. Right to claim possession, section 19.3, the right to claim possession of the unit. The association of allottees also has the right to claim possession of common areas. Right to refund and compensation, section 19 subclause 4, if promoter fails to give possession according to terms of the agreement or due to discontinuance of business, the allottee has the right to withdraw from project and receive a full refund plus interest. If they choose not to withdraw, they can entitle to interest for every month of delay until possession is handed over. Right to documents, section 19 subclause 5, the right to receive all necessary documents and plans, including those for common areas, after taking physical possession. Right to structural integrity, section 14, the right to have any structural or workmanship defect fixed by the promoter free of charge if discovered within 5 years of handover. Duties of allottee, to ensure the project remains financially viable and orderly, allottees have statutory duties. Duty to make timely payments, section 19.6, every allottee is responsible for making payments at the time and place specified in agreement for sale. This includes their share in registration charges, municipal taxes, water, electricity charges, and maintenance fees. Duty to pay interest for delay, section 19 subclause 7, if an allottee delays a payment, they are liable to pay interest at the prescribed rate. Note, under Rera, this rate must be identical to the interest the builder pay the buyer for delays. Duty to participate in registration, section 19 subclause 9, the allottee must actively participate in the execution and registration of the conveyance deed of the property. Duty to form an association, section 19.9, allottees are obligated to participate in the formation of an association, cooperative society, or federation to manage the project's common areas. Duty to take physical possession, section 19.10, an allottee must take physical possession of the property within 2 months of the issuance of the occupancy certificate. Liabilities of allottee, failure to fulfill the duties mentioned above can lead to specific legal liabilities. Financial penalties, section 67 and 68. If an allottee fails to comply with orders of authority, they may be liable to a penalty for the period of the default, which may cumulatively extend up to 5% of the plot or apartment cost. If they fail to comply with the orders of appellate tribunal, they can face imprisonment for up to 1 year or a fine up to 10% of the cost or both. Cancellation of allotment. While Rera protects against arbitrary cancellation, a promoter can cancel an allotment if the buyer persistently defaults on payment as per the agreement for sale, provided the promoter follows the specific notice period and rules set by the state Rera. That was all for this video. See you in next video. Till then, please like, share and subscribe. Thank you.